When I question a doctor during a pretrial question and answer session known as a deposition, why is it that some defense attorneys continue to object over and over again to my questions, whereas other attorneys simply allow me to ask my questions without making any objections at all? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. And now, during the course of the lawsuit, we have an opportunity to go ahead and question the doctors whom you have sued. This is known as a pretrial question and answer session. We lawyers call this a deposition. It's also called an examination before trial. Now, this takes place in the defense lawyer's office, in his conference room. There's no judge present, there's no jury present. But there is a court stenographer there to record all of my questions and all of the answers that the doctor gives. Now, you should know that the answers that the doctor gives me represent his sworn testimony. And now, that testimony carries the same exact weight as if he is testifying at the time of trial in front of a jury. So now, there are times when I will ask questions of a particular witness, of a doctor, and now the attorney who represents the doctor will raise one objection over the next, after the next, after the next. Now, what do I do in that instance? Well, you should know something really important. In these civil cases where an injured patient is trying to obtain money as a form of compensation, this does not involve criminal activity. We're not trying to put somebody in jail. We're not trying to take away somebody's medical license to practice. Instead, we're trying to understand what was done and why. We're trying to understand what was the standard of care in this scenario. And now I'm entitled to ask a series of questions. I'm entitled to ask many questions. Questions that could go on for hours and hours. You should also know that even if the doctor does not like the question I have asked, he still has to answer the question. But there are only two real instances where the defense lawyer would be well within his right to tell his client, the doctor, not to answer the question. As an example, one question would be, hey, Dr. Jones, what did you and your lawyer talk about before I started to ask you questions this morning? Objection. That's confidential. It's privileged. You can't ask that, counselor. And he'd be absolutely right. I cannot ask the doctor, and he will not tell me the conversations that he had with his lawyer, because that is confidential. The second question that I wouldn't be able to obtain an answer from is where I ask a question that is so off the wall, such as, hey, Dr. Jones, how many times do you beat your wife each night? And the defense attorney says, what, are you nuts? Are you crazy? What does that have to do with anything? You have no evidence of that. It's got nothing to do with any issues in this case. Are you just making this crap up? So that's another off-the-wall example where the doctor clearly would not have to answer that type of question. But pretty much everything else, the doctor will have to answer. Even if he doesn't want to answer it, even if he doesn't like my question, even if the defense lawyer doesn't like my question. Now, there are instances where I don't ask the question very well, where it's not worded properly. Or I ask two questions contained within one, and if he says yes, we don't know whether he's answering the first part of my question or the second. That's called a compound question. And the defense lawyer would be well within his right to say, Mr. Oginski, I object to that question. Please rephrase it. So now I'll go ahead and ask it a different way. Or I'll ask it, there are 10, 15, 20 different ways I can ask the same type of question. Fine, I'll do that. But there are some attorneys who, no matter what, no matter how polite I am, no matter how respectful I am of the doctor, they will object to every single question. Now, why would they do that? Well, there are a couple of reasons why I think they do that. Number one, inexperience. Number two, they're not really a trial lawyer. Because if they were really a trial lawyer, they would know, hey, listen, I don't have to object to every single question. Why? The questions that I ask and the answers that are given then get transcribed by this court stenographer and put into a booklet. And now we can use that booklet at the time of trial. And you should also know that if the defense wants to try and throw your case out before we ever get to trial, they will take that testimony in the form of that booklet and now use it to support their argument to the judge. Hey, listen, at line 17 through line 22 and the following pages, the doctor gave reasons why there's no liability here. And you should know that at trial, I can use that sworn testimony to contradict something that the doctor has said. Some of these attorneys believe that if they don't make an objection during this pretrial question and answer session, that they can't make the objection later on trial. When in fact, that's not true. They can. And that's why you'll find that some of the best trial attorneys on the defense side simply go ahead and allow me to ask questions uninterrupted. There are other defense attorneys who turn around and, you know what, say, I don't need to make all these objections. I can make these objections at the time of trial. Just because I don't make them during the deposition doesn't mean I can't make them at trial. And that's absolutely true. But there's still other attorneys who say, you know what, I'm going to make my objection. I'm going to preserve the fact that I've made my objection and I've done my job, but I'm still going to tell the doctor he has to answer the question. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I do realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.